Your Worship, for record Richard Chief Special Attorney. Your Worship, this matter is coming up today for further mention. Wish to inform Court, Your Worship, that inquiries of this matter are still ongoing, and we ensured that the remaining inquiries are expedited to ensure the committee of the accused persons to High Court. It is on that background, Your Worship, that we seek an adjournment. So,
for purposes of management of expectation, but also in the best interest of the accused persons and justice of the case. And since this order will be made anything, kindly ask the state to give us an indication of those remaining inquiries so that we know, otherwise we might be chasing the wind. Because if it says remaining, the assumption is that some have been done. So some are remaining. It would be a good thing to know some of those which are remaining so that we respond.
Has really been disturbing to us. And it's high time the court addressed that issue. Actually, they take it that they have to take their time, 6 months within which to conduct investigation. That is not the spirit of the Constitution. The spirit of the Constitution in Article 28. One of the key tenets of the right to fair hearing, or fair trial, is speedy investigation, speedy trial in itself, and all the pre-trial processes to be conducted in a very expeditious manner. That is the spirit of the Constitution. And it is that spirit we seek this honorable court to uphold. And we are inviting the prosecution to indicate as to when they are finalizing this process. My learned friend here has talked about legitimacy expectation. It's important. Trial by ambush. It's not permitted under our laws. So, may we have an idea on what they are doing and how they expect, when they expect to be done with that process, and we prepare accordingly. That is all. It's a very simple thing that we are demanding for. And it's within the right of the accused persons that are all the free trial processes must be conducted expeditiously. So very much.
Just so that this honorable court is not misled, I would kindly request, again, trial by ambush, Mr. Richard to show us. We expect that his undertaking that because we are now in month 3, perhaps it means that in April, when the 6 months are done, we will be ready. Also, just to remind my colleague that the matter is not starting today in this magistrate's court at Nakawa. It started a long time ago. To the extent that we know Mr. Richard and his team represent the state which causes the arrest. caused the arrest of these individuals from November up to now. So I recite what my colleague said, that in Article 28.1, the entitled to a fair, speedy trial. And in regard to what we asked for so that we can plan, in Article 28, Sub-Article 3, Paragraph C, we are entitled to adequate time and facilities to prepare for the defense. We are sticking to facilities. We're not asking for money, but so that we can plan appropriately for the accused person's defense. So that is our request. And we assume that the need for them to keep things in their pocket is overridden by the public responsibility of fair trial. Nothing stands in the way of that principle. Kindly ask to give us guidance on that.
Aggravating my senior colleagues. To emphasize about FA, he's been in custody for 1 year and 4 months. Our state has indicated that they are still in the contested period of 6 months. Of course, I believe there is no legal basis for that. For that 1 year, we submit that it is been time enough for them to make any disclosures if necessary. So,
however, not at this stage of investigations, but rather at the point of hearing. And this prayer shall be made to the court that will be handling the matter. So, now, the state is empowered to expedite the investigations so that the defense can get their necessary prayers answered at the right forum. As of now, all the accused persons are remanded, and the matter is adjourned for mention to the 28th of March, 2025 at 10. Application number 001 of 2025 arising out of Nakawa criminal case number 008 of 2025. Uganda Passport, Dr. Besigye, Besigye, Captain Bensola.
May it please this honorable court, Jatiko Thomas, Assistant DPP, presenting the state this matter, together with my learned friend Richard Bill Bumbuka, Chief State Attorney, and Eunice Mbine, Senior State Attorney.
It's evident these people are just struggling to manufacture evidence. You heard when we asked as to when they are likely to complete the investigations, they were cagey. When you look at the matters before this honorable court and all the allegations they are making, one would expect that they would be ready by now to assemble the evidence which they intend to rely on and make a summary of their case, and committal papers should be made by now for the matter to be forwarded to the High Court for hearing. They indicated from the record that the file was transferred to police on the 11th of February. That's what they have indicated in the affidavit sworn by one of the officers investigating this matter. But you all know this matter started way back on the 16th of November when Dr. Besigye and Obed were abducted and kidnapped from Kenya. They were taken to the General Court Martial, and it took some time before this matter was brought here. But now, in a surprise twist of events, they seem to suggest that actually, prior to the DPP taking over this matter, there was no investigation conducted by any government agents, which is really baffling and disturbing. Because according to what the police and the prosecution are indicating here, they are just starting on the investigations now. That actually they commenced investigations on the 4th day of March. Today is 7th. This week is when they started to conduct investigations. But they have also indicated they took over the matter on 11th Feb. But since then they had not started on the investigations. Now they have started. They have put in an application dated 5th. Actually, they filed on 5th. That was Wednesday this week, seeking for an order of court to allow them access all the information regarding the phone numbers of Dr. Kiiza Besigye and Obedi Lutale, which have been in their custody since the 16th of November last year. Now they are just putting an application this week that they want to access those information. They want to access that information regarding all those phones, the communications, the records concerning those particular phone numbers or lines. They are talking about 5 phone numbers, 5. And there are a couple of issues that we intend to raise regarding the same. They are not for now. But what is of concern right now is the way they wanted to stampede the court to have this matter heard today. You could imagine. Filed on Wednesday, served on Thursday afternoon, and they wanted it to be heard Friday morning. We opposed this. We had to oppose it in the strongest terms possible. We had to oppose it because we believe it's an ambush in the first place, which is not allowed under the law. Secondly, it's an attempt to manufacture evidence against Dr. Besigye and Obedi Lutale. Court has fixed it for hearing on Friday the 14th. We are going to study it. We're going to interact with our clients and then file all the necessary papers required to oppose this application, all these maneuvers being made by the state to manufacture evidence. It's all about manufacturing evidence. Actually, to sum it up, they are on a fishing expedition trying to scratch around to gather evidence which they think can help them make out a case against Dr. Besigye. Apparently, they don't have any. So basically, that's where we stand.